the police can take your cash, your car, even your house. And here's the part almost nobody believes until it happens to them. They can do it without ever charging you with a crime. No arrest, no conviction, sometimes not even a ticket. It's legal. It happens tens of thousands of times a year. And once they've got your money, you're the one who has to fight to get it back. So how is that possible in America? The answer is a strange, centuries-old legal trick. And once you see it, you can't unsee it. Start with what you probably assume, that the government can't take your stuff unless it proves you did something wrong. Charge you, convict you, then maybe take what you gained. That's true for one kind of forfeiture. But there's a second kind, running on a completely different track. And it doesn't need any of that. Here's the trick. In this second kind, the government doesn't sue you. It sues your stuff. That's not a figure of speech. Real court cases have names like United States versus $12,000 in cash. The pile of money is the defendant. Lawyers call it an in rem case, Latin for against the thing. So instead of the state versus John Smith, it's the state versus one 1996 Cadillac. The car is on trial, and a car has no right to a lawyer, no presumption of innocence, none of the protections you would get. Put the two side by side. Criminal forfeiture comes after a conviction. The government has to prove you guilty beyond a reasonable doubt, the highest bar in the law. Civil forfeiture in most states needs none of that. No conviction, no charge, just a lawsuit against your property on a much easier standard. Same word, forfeiture. Two completely different worlds. So where did this bizarre idea come from? Mostly the high seas. Centuries ago, when a ship broke the law, smuggling, piracy, the government could seize the ship itself, even if the owner was an ocean away and couldn't be hauled into court. It was easier to put the boat on trial than to chase a man across the world. The Supreme Court blessed that logic early on. In an 1827 case, it said the thing itself can be treated as the offender. Guilty property. That fiction never went away. Now here's what makes it sting. In a civil forfeiture case, the government's bar is low, and for a long time, the burden was actually flipped onto you. The government showed a hint of suspicion, and then you had to prove your own cash was innocent. A law called CAFRA moved that burden onto the government in the federal system back in 2000. But it didn't touch the states. And in many of them, you can still be the one stuck proving your own money is innocent. And you don't even have to be the wrongdoer. In 1996, a woman named Bennis lost the car she co-owned with her husband because he, without her knowing, used it to meet a prostitute. She had done nothing wrong. The Supreme Court said the car could still be forfeited anyway. Being an innocent owner, the court ruled, is not automatically a defense. So step back and ask the obvious question. If this is such a blunt tool, why do police use it tens of thousands of times a year? Follow the money, literally. For most of American history, seized property went to the government's general treasury. The seizing agency got nothing extra. Then, in 1984, in the middle of the war on drugs, Congress changed one crucial detail. It let law enforcement keep what they seize in a dedicated fund. Suddenly, taking your property could directly pad the budget of the very agency that took it. Critics have a name for what that incentive creates. They call it policing for profit. Their argument, and it's shared across the political spectrum, when an agency gets to keep the cash, you've quietly turned law enforcement into a revenue business, with a reason to seize first and sort it out later. Supporters push back hard, and we'll get to their side. But first, see how the money actually moves. Say a state passes a strict law limiting forfeiture. There's a workaround. Local police can hand the case to a federal agency, forfeit it under federal rules instead of their own states, and get up to 80% of the money back. The stricter state law? Sidestepped. And the scale is staggering. By one count, from the Institute for Justice, a group that fights these cases, states and the federal government have taken more than $80 billion in forfeitures since the year 2000. A large share involved people who were never even charged with a crime. Here's the quietest part of the whole system. The typical amount taken is small. The Institute for Justice puts the median cash seizure at about $1,700. To fight it, you may need a lawyer costing several thousand. So do the math. It can cost you more to challenge the seizure than the seizure is worth. Critics say that gap is no accident. It's the incentive the system creates. Most people just walk away. Not because they were guilty, because fighting is a losing bet. And this isn't just critics talking. The government's own watchdog said it. In a 2017 report, the Justice Department's Inspector General looked at the DEA's cash seizures and found that most were done with no judge involved at all. And in a sample of stops with no drugs found, most couldn't be linked to advancing any actual investigation. The report's own warning. When seizures don't end up advancing a case, it risks looking like the point was the cash itself. If you saw our video on bank records, this next part will feel familiar. Federal law makes it a crime to break your cash deposits into smaller amounts, to dodge the bank's $10,000 reporting rule. It's called structuring, and the government used civil forfeiture to seize entire small business bank accounts on that pattern alone. No drugs, no fraud, no other crime. A convenience store owner in North Carolina had over $100,000 taken. An Iowa restaurant owner lost her savings. Neither was charged with any underlying crime. Their only offense was depositing cash in amounts a computer flagged. After public outrage and a string of these stories, the IRS changed its own policy back in 2014 to stop these seizures. And Congress later wrote that limit into law in 2019. But for the people it happened to, it still took years and lawyers and headlines to claw their money back. So where are the courts in all this? Have they put up any limits? Yes, a few real ones. And the most important came from an unlikely champion, a man and his Land Rover. Meet Tyson Timbs. After a drug conviction in Indiana, one that carried no prison time, just home detention, the state seized his Land Rover, a car worth about $42,000, which he'd bought with money from his late father's life insurance, not from crime. The problem, the maximum fine for his actual offense, was $10,000. The car was worth 4 times that. In 2019, the Supreme Court ruled unanimously that the Constitution's ban on excessive fines applies to the states, and a forfeiture can be so big it becomes an unconstitutional punishment. That's the key limit to hold on to. It doesn't ban forfeiture. It just says the punishment has to fit the crime. Take a $40,000 car over a small offense, and a court can say that's too much. The court has drawn one more clear line. Before the government can take your actual home through forfeiture, it generally has to give you notice and a hearing first. Why the house and not your cash? Because a house can't be driven across a state line overnight. The old "seize it before it disappears" excuse doesn't apply to real estate. But here's the catch, decided just recently. In 2024, the court considered people whose cars were seized and then held for a year or more, while their cases slowly wound toward a final hearing. with no quick, early hearing in between to challenge the hold. The question, don't you at least deserve that early check? The court said no. You're owed a timely final hearing, but not a prompt preliminary one. So the government can hold your car for months while the clock runs. Even inside the Supreme Court, unease is growing. Justice Clarence Thomas, writing on his own, not in a binding ruling, has warned that modern forfeiture has led to, in his words, egregious and well-chronicled abuses, and that it frequently targets the poor and other groups least able to defend their interests. It carries no legal force. But when a sitting justice publicly questions whether the whole system is constitutional, that's a signal worth noticing. And the court may be about to weigh in again. In 2026, it agreed to hear the case of an 82-year-old retired Alaska bush pilot. Years earlier, the state took his airplane, worth around $95,000, after he flew some beer toward a village that bans alcohol. The question the justices will decide: when they measure whether a forfeiture is excessive, do they have to weigh how blameworthy the actual person was, or just the offense in the abstract? A ruling could reshape the limits for everyone. Meanwhile, the states are all over the map. A handful, Maine, New Mexico, Nebraska, and North Carolina, now require an actual criminal conviction, at least on paper, before most property can be forfeited. New Mexico and Maine went furthest, also cutting off the profit incentive by sending the money elsewhere. But in many states, police can still keep the lion's share of what they take. Where you live changes your rights dramatically. In Congress, the fix has a name, the FAIR Act, and a long history of going nowhere. It would raise the government's burden of proof and shut down that federal workaround. It's been introduced over and over, with backers on the left and the right. As of 2026, it still has not passed. So for now, the rules depend on which state and which agency you're dealing with. So, is civil forfeiture a vital tool or a due process nightmare? Honest people genuinely split, and this video isn't here to decide it for you. Both sides are staring at the same fact. Property can be taken on a civil standard with no conviction. Here's what tells you this isn't a normal political fight. The groups lined up against civil forfeiture include the ACLU on the left, and the Heritage Foundation and libertarian legal groups on the right. It's one of the few issues where those names sign the same letter. When the left and the right agree the process is broken but it keeps going anyway, critics say that tells you who's really benefiting. The budgets it funds. Supporters see it differently. They'd say funding good police work is a feature, not the motive. But a coalition that wide is genuinely unusual. So what does this mean for you? Not legal advice, just the landscape. If your property is ever seized this way, the burden to get it back often lands on you. File a claim, hit strict deadlines, and be ready for a process that can outlast your patience. Knowing the word forfeiture, and that a hearing and deadlines exist, is the difference between fighting and just walking away. So, can the police take your cash without charging you? In much of America, yes, by putting your money on trial instead of you. There are limits now. Punishments can't be wildly excessive. Your home gets more protection, and even some justices are uneasy. But the core machine is still running. Whether that's a necessary weapon against crime or a loophole around the Constitution, that part, you get to decide. Now you know,